can. Okay, so we will start now with this Trade Secrets webinar organized by Jones Day. Hello everyone, good afternoon, good morning if you're at the other side of the Atlantic. My name is Marta Delgado. I'm a partner in Jones Day, and we'll be doing today a roundtable to discuss how to protect trade secrets from cyber attacks. We've got a very nice roundtable with a mix of experts from companies such as Frédéric Lemoff, who's Senior Corporate Intellectual Property Counsel at Biomérieux, who's in charge of the digital assets of the company, including data protection and research and development. We've got Lorenzo Grillo, he's Managing Director, Cyber Risk Services at Alvarez & Marshall, disputes and investigations with more than 35 years of experience in forensics related to compliance in the cyber world. And we've also got three partners from Jones Day in the intellectual property practice and cybersecurity, privacy and data protection. Rebecca Swindles, who's a partner in London, Tamar Vouvet, who's a partner in Paris, and Jörg Hladek, who's a partner in Brussels. So as I was saying, this is going to be focused as a roundtable. We can go to the next slide, please. We will be doing some introductory comments. Next, go to the current landscape of cyber threats for trade secrets. We'll speak briefly about what are trade secrets, what's the legal framework, what are the threats, how to minimize the risks, some enforcement and remedy tips, and we'll get at the end with a few questions from the audience. Just a few introductory remarks about why is this a matter that should be of great interest to companies. It's been published that 95% of the cybersecurity issues worldwide are due to human error. However, in Europe, in the manufacturing, ICT, health and financial sectors, 94% of the cyber attacks are driven by industrial espionage. 435% of increase in ransomware was seen in 2020 worldwide, which is huge, of course. And it's been noted by the World Economic Forum that the average time for the intrusion to its detection of the cyber breach is of 469 days in Europe, which is a lot. Cyber theft of trade secrets means 60 billion euro losses in economic growth in Europe and a potential loss of 1 million jobs. With these figures, we go next to see what's the current landscape for cybersecurity and trade secrets. What are the threats and trends? What are trade secrets? Why they are key, etc. And we will start asking Jörg if you can tell us a little bit about the current landscape and the threats and trends.
Yeah, sure. Thanks, Marta. So I think we see, as you have already indicated, really a big increase in terms of ransomware attacks, especially on commercially sensitive and confidential information at organizations, including trade secrets. So there is really a push for that. And it's not focused on one industry sector, as you may imagine. So it's really across the board. I mean, obviously, we have here companies representative today from the life science sector. And that sector in particular is exposed with great risk for a number of reasons. And we see that hackers really focus on that industry sector for a number of reasons, including that, of course, more and more work is done remotely, more and more work is happening in the cloud. So there is this vulnerability that, is kind of attractive to hackers and groups to go after. And so we see really that uptick. I also want to mention, we mentioned the cost in general to economy or society, but also the cost for company, right? And based on our experience, the average, and the studies about this, the average cost could be in the millions to handle a data breach that usually, is global of nature because data and files information moves global all the time. So usually companies are hit across the globe. If there's one incident, then it affects, systems, and IT systems are global. So with one hit, actually, there's a lot of exposure. So that's the external factor of these incidents, what we see in the landscape right now. There's also, I think, an internal side of things, right, Thomas, on the insider front.
Yes, Jörg, it's correct that alongside those cyber attacks and ransomware, the trade secrets are also at risk from insiders, be it existing employees or existing partners, which actually have access to the company and the business data, and which can easily make copy of it and make illegal use of that. Because we know that trade secrets are among the very valuable assets of companies, it's of course of primary importance for companies to protect them. And actually, I would say there are mainly three reasons to put in place policies to protect trade secret. The first one, of course, is to try and prevent those cyber attacks or to make them fail when they are made. The second reason is also to be able to reassure investors or partners which increasingly want to have information about existing policies within companies before actually investing or entering into commercial relationship. The third reason to put those policies in place, and that's going to be the topic of our discussion today, is that it is one of the conditions to be able to benefit from trade secret protection. This being said, I think we're interesting to learn, Frederick, about how businesses are able to cope with those challenges.
Yes, first I would say that bioMérieux is a life science company, as it was said, managing many sensitive data, patient data, R&D data, confidential third-party data, because we partner with many organizations, and employees' data. Plus, with the digital transformation of product and services, confidential databases, especially the one used for our artificial intelligence solutions, take more and more weight in our competitive advantages. So the impact of a data breach would be very detrimental for bioMérieux. Not only our assets would be destroyed, but we would be in great trouble with GDPR organization and also governmental administration regulating life science product. And in trouble also with our partners, without speaking of the reputation costs of the data breach. So cybersecurity has always been an important topic for bioMérieux, and long before the Trade Secret Directive, our IS department put in place a very stringent cybersecurity measure and has a dedicated team for that. There are many challenges to cope with cybersecurity. And cybersecurity is not only about taking global technical measure that fits all cases. Cybersecurity requires to know exactly what are the data, where they are stored, how they are processed, by whom, what are the roles and responsibilities of people accessing them, what is the value of the data, and how we can share them with our partner when we need to do so. And all those pieces of information directly determine specific measures to protect confidential information depending on their sensitivity. In addition, cybersecurity is not only a matter of IS department. It involves all the employees of the company that shall be trained and aware of those threats. They are an essential part of our cybersecurity solution.
Okay, and taking a step back for a second to get a clearer view of trade secrets, their regulation, what's their definition, could you give us an initial view, Rebecca, from the legal perspective?
Yeah, sure. I mean, so the main piece of legislation in Europe is the Trade Secrets Directive. It's similar in many ways to the US Defend Trade Secrets Act. Both were introduced around the same time, back in 2016. And I think the directive's been really important in harmonizing and clarifying the law of trade secrets across Europe. Because, of course, prior to that, trade secrets litigation was dealt in quite a disparate way by under national law, such as the common law of confidence in the UK. And that led to great differences, I think, in the ways in which laws on trade secrets were being applied by courts from country to country. So now we have clarity and consistency across Europe, and not least in providing a clear definition finally on what a trade secret is, which I think Thomas will expand upon, and how a trade secret can be infringed, but also importantly in ensuring that there are sufficient court procedures in place for protecting the confidentiality of the trade secrets that you're litigating about. So that should encourage businesses to not be concerned about bringing trade secrets cases. And so I think it's served to raise the profile of trade secrets in Europe, and I think businesses are becoming more aware and more savvy in the way that they are litigating trade secrets now. I mentioned
what's the definition of trade secret under that directive, which seems to be the relevant point here?
Sure, Marta. Well, the definition has been harmonized, as Rebecca just mentioned, and we now have a definition which is based on 3 elements, which is, I would say, still quite similar to the definition that we knew earlier from the TRIPS agreement. There are 3 conditions for information to be treated as a trade secret. First, the information as a whole, by that I mean in its precise configuration and assembly, must not be generally known or readily available to people in the industry. That's the first condition. The second condition is that this information must be of commercial value because it is confidential or not known by others. The last and third condition that we will develop later on during our webinar is that the holder of the secret must take reasonable steps according to the circumstances to keep the trade secret secret. So just to be a little more practical and give a few examples and still maybe staying in the first place in the healthcare industry, trade secrets can be found almost at every level of R&D and exploitation of products or services. I mean, first, a lot of fundamental and upstream research rely on confidential information, on knowledge that are not known to many. That's why some institutions have expertise in that, and this expertise relies most of the time on trade secret. Secondly, all the research of trial and error is also a great source of trade secret, not only knowing what works, but also what doesn't work gives competitive advantage to companies. Secondly, even once a product has been designed, being able to scale up production, to have a robust manufacturing process, in particular in the drug industry, is also subject to many trade secrets which exist alongside to the patents that may have been filed and are usually filed to protect the invention. On top of that, of course, we should mention data, be it patient data, that can be used for many things, either R&D, for diagnostic, for e-health applications, for AI. All this really relies on trade secret. And the last element that should be reminded is really trade secret of economical value, be it market intelligence, client data, list of clients, financial information, etc. So it's not only technical information, but also economical and financial information.
No, let's go back to the previous slide. So I would ask Rebecca, what's how to protect those secrets that some of which have been mentioned by Thomas as an example. What are the reasonable steps
Yeah, so the directive is quite vague on this, actually. It just says reasonable steps under the circumstances without expanding on that. So it's really been left to the courts to decide what that means. And fortunately now we're a few years in from the directive that we've got court decisions to help us navigate that. And I think what is clear is that proportionality is quite key here. So the expectation of the courts is that businesses must take protective measures which are both adequate and proportionate when considering the value of the trade secret in question. So for a large organization which may have a variety of different types of confidential information, from maybe relatively low value up to really technical trade secrets, which may be sort of crown jewel status, it's really important to have a robust auditing of that information, to categorize it, and then to put in place the right processes and procedures for protecting that information according to its value. So if you're talking about what I refer to as crown jewel sort of status information, such as the Coca-Cola recipe or Google algorithms, the court is going to expect such high value information to be very, very closely guarded. Restricting access to it to just a handful of key individuals on a need-to-know basis, and for all access to and disclosure of that information to be closely monitored and tracked and evidenced, so that if you get to court, you've already got all of that information to show that you've taken the right steps required under the directive. So I think a sound and effective document management system is a must here, and we're not just talking about steps internal to a business. I think the case law that's coming through the European courts is also showing that it is a requirement for businesses to be looking externally in terms of protecting their trade secrets. So we're talking about restricting and monitoring third-party access to your information when you're collaborating with third parties, when you're doing due diligence for potential mergers and acquisitions, etc. So obviously NDAs will play their part and are an absolute bare minimum here. But I think depending on the value of the trade secrets, we're talking about much more stringent procedures being put into place.
It's not always easy to identify, right? The trade secret, Thomas or Rebecca. What are the challenges in identifying them for the same companies that want to protect them?
Well, I would say one of the challenges, of course, to identify them, but also to be able to reconcile three situations which seem completely incompatible. I mean, first, a lot of information, and I would say all the information is now stored electronically, accessible on company's server. And so it's so easy to simply copy that information, circulate the information. I mean, it's just copy paste, drag and drop, etc. Things you can do with one finger. The second aspect is that this information needs to be shared within the company. Very broadly, companies are doing business globally. They have plants in different countries, several plants in a country, and all of them need to share that information, in addition to employees who might be working remotely. So this information needs to be shared, and also needs to be shared outside the company each time a company would engage in joint development agreements or things like that. So it's really those two situations that need to be reconciled with this obligation to protect and put measures to keep this information secret. So the real challenges is to find this right balance.
Marta, if I may just add one comment, just because I think it's quite an important one, given the the audience here is that the reasonable steps test under the directive aligns very nicely and neatly with the reasonable measures test under the US Defend Trade Secrets Act. So this just makes it clear easier, I think, for multinational and global companies to meet the standard of protection required by courts. You know, you may be litigating in Europe on trade secrets which have arisen in the US or vice versa. So the fact that the reasonable steps test is similar across the pond, it makes it a lot easier for businesses to navigate.
Yeah, absolutely. Good point. And I guess from the business perspective, Frederic, this looks a little bit like what we've been doing in terms of compliance with the GDPR. Is that your experience too in bioMérieux? You're muted.
Yes, absolutely. Just a few words in terms of investment and people involved. Trade secrets is resource demanding and involve many departments, the IS, the IP, the legal, for us also the regulatory affairs, and more importantly, the privacy department. And privacy department is a very important stakeholder for trade secrets because trade secret and GDPR have a lot of in common regarding their goals and processes to protect confidential information.
Would it be then, Frederic, on that point, would it be then a fair statement to say that since there is no specific legal framework how to approach trade secret protection and nothing specific, right, on security or in data in that respect, that, you know, GDPR or companies who have done a GDPR compliance program to use that methodology, to use the framework, policies and procedures that companies have done under GDPR to try to address and capture trade secret protection, at least to some extent, because there's personal data, as you explained to us earlier, in many different environments.
Absolutely. And you have to know that the amount of data in the GDPR scope is very large, including a lot of non-personal data, such as R&D. Just have in mind that information are created and managed by individuals. And because individuals are involved, there are always at some point personal data, so that GDPR impact must be assessed, data must be mapped, and we have to put in place a regulatory security measure and so on. Just an example, think about a student report regarding pure R&D data. The name of the author is in the report. That is a personal information that is in the scope of the GDPR. So naturally, the reports of our students, for example, for R&D topics are processed by GDPR measures. So I would say that in practice, the security measures of confidential information is mostly done by IS, cybersecurity, and privacy department. And our IP department is in charge of checking information going in and out of the bioMérieux, along with confidentiality agreements. Hopefully, we are 3 big departments that share the cost and the measure regarding trade secrets.
Very good. So going now from the trade secret, what it is, how to take reasonable measures, and what's a compliance system in practice. We'll take it on the next slide to the cyber threats. What's the cyber breach and what are the trends? Lorenzo, if you want to say a few words in your experience.
Yes, thank you, Marta. Yes, if we speak about the most important threat nowadays, as we have seen in the previous slide, is ransomware. And the first question would be, but how a ransomware attack can be related to the confidentiality of trade secret? Because, you know, if you think about the first type of ransomware was just with a goal to disrupt the company systems by encrypting data. So just related to data availability. But if we speak about the new evolution of ransomware, what we see today is that it has evolved to include the stealing of data in parallel to their encryption, and so adding the loss of data confidentiality to that one of data availability. So when asking for a ransom, the attackers are not only threatening the company with unavailability of their data, but also with the chance to disclose those data on the internet. And so that is the most important part related to trade secret. An interesting new business model using data stolen with a ransomware attack is the so-called data brokerage. What is data brokerage? The attackers sell those data and the access to those data as well to the highest bidders. And those bidders can also make further attacks to the same company using the access given them by the previous attacker. So this is another important aspect of being very careful on ransomware attacks, also on trade secret.
There's also another very relevant type of cyber threat, which is through the employees and partners. And in our experience in the legal teams, that's not negligible, is it, Thomas?
No, it's a fact. I mean, we see the numbers of litigation increasing almost worldwide on that. And if you look at the typology of those trade secret violation cases, we can see that most of the cases involve breach either by employees or usually departing employees or partners that are bound by contractual obligation and therefore violation of trade secrets that result from, I would say, insiders or people who had access initially to the information in a legal manner, but which misuse that. And again, that's clearly situations in which the access was easy. There's no breach of anything. It's just the use and the copy that is critical. And yes, in practice, this is gaining importance. Of course, what is behind that is, of course, the creation of competing activities or simply using the technology to develop for others, etc. So clearly, trade secret protection should definitely encompass those use.
Okay, good. So we've seen in this slide, we've seen the cyber threats, and if we move to the next slide, we'll deal with next with how do we minimize the risks? How do we deal with a cyber breach? So what are the means? What are the tools? Rebecca, Lorenzo, if you want to jump in.
Yeah, sure. I mean, I can kick off, focusing more, I guess, on the type of risk that Thomas just mentioned, the sort of the rogue employee or someone who you've collaborated with who had legitimate access and then misuses trade secrets. And a lot of this just comes back to the reasonable steps that we talked about earlier, and they need to address a really quite wide range of risks, both human in terms of employees or collaborators, and technical, both internal and external. I think Lorenzo will be able to speak probably better than I will about the more technical aspects, but I mean, certainly at a very basic level, obvious steps that businesses really should be taking includes having a dedicated team to be responsible for the protection of the business's trade secrets, drawing up a trade secrets policy, which is then communicated to employees to ensure that they understand it, and who then sign off on it to say that they will comply with it. Obviously, to have clear policies for onboarding employees to ensure that they don't bring with them third-party trade secrets, and critically with policies for dealing with departing employees to ensure that they have returned all confidential information. And this has become all the more crucial during the pandemic and now post-pandemic, given sort of the very mobile workforce and remote working workforce. Other things to be looking at are obviously contracts with third-party collaborators to ensure that they protect your trade secrets. And then the type of things that I mentioned before about access to documents and information and monitoring that. Lorenzo, I'm sure you've got some good tips on the sort of technical side of things.
Yeah, so let's say I think that first of all, as you said, Rebecca, and you mentioned about various different countermeasures to try to minimize the risk of a cyber breach. And in general, my idea is to have an holistic approach to cyber, in the sense that you have to cover governance, you have to cover processes, you have to cover technology aspects, and not just putting in place some security solution and understanding and thinking about you are secure. No. And also you have to think about what is the level of risk that they can mitigate using each of the countermeasures we are thinking about. You have to quantify that risk, and also more and more important nowadays, just knowing that compliance is not enough and can give you a full sense of security. I've seen many times companies 100% compliant to relevant regulatory requirements, but then the real level of cybersecurity was very low. For example, I've seen many technologies in place covering security of data, security of network, security of systems, any kind of solutions. But then, for example, no one dedicated to security. So no person dedicated to security. So how you can manage those kind of solutions? And then after that, something can happen. So no matter what you put in place and mitigate your cyber risk, something can happen, and you have to be immediately prepared. First of all, to detect an attack. And so nowadays is a must to have a security operations center that is usually a managed security service provider, so an external provider monitoring 24/7 all the events that comes to your company. And then, as soon as you have that in place, you can respond efficiently and effectively to an attack if you detect immediately something, and you can minimize the impact. As soon as something happens, also to respond efficiently and effectively, first of all, moment zero, a cyber war room. It is not a cyber war room just done by technical people, by the CIO and the CISO. All the relevant stakeholders of a company should be there, because cyber is a company issue. And so there you have to be 24/7, the CEO, the COO, the CRO, the CFO, the HR department, the legal department, the PR company, everything there, because with their responsibility, with their roles, and so following strictly the another must, the cyber incident response process. Remembering that cyber is not just an IT issue.
Yeah, sure. Thanks, Lorenzo. And this leads to a question of, if it's difficult to spot it, it's difficult to identify. It's absolutely essential to have a team ready to identify. And how does one investigate a cyber hacking event? Georg, do you have any insight on that in your experience?
Yeah, in practice, usually, and that brings us to what we discussed several times, incident preparedness is very important, because our recommendation would be, based on experience, to have a trusted forensics provider engaged, earlier, of course, in the course of business, not just when the incident happens. And then, besides other elements, that provider would then have to be tasked and steered, usually by, for privilege purposes in the US, for example, if the incident is global, by the law firm, to make sure the findings are privileged. And then so also the forensic provider would have to identify what kind of data is involved, in which locations globally, which jurisdictions apply, what data is it specifically, is it personal data, is it not personal, to our discussion earlier, right? That's all very important. And then also there needs to be legal guidance given to the forensic provider, specifically what to search, how the keywords are organized, what time frames should be searched, what happened. So that's very important. And also identify potential disclosure issues, such as when hackers threaten to disclose information. Sometimes they say we got into the system and we have the data, but maybe they're still in the system, or they say we have taken the files, for example, and they're staging it. That means actually they're prior to maybe disclosure or threaten using that in the context of ransomware. So there's a lot of factors that can be done on the forensic side, identifying exactly what happens. We see also example where it's not clear if they actually can access the data may be encrypted, right? Or they have done the encryption, or the encryption was by the organization itself. So there's a number of these things that have to be carefully analyzed, and that process is very important for a number of legal reasons. When you think of, for example, notification requirements to, if it's personal data involved, to data protection authorities in different countries, to law enforcement agencies, especially in the United States, and a number of other reasons. And once facts are established, that's very important. A forensic report has to be prepared potentially. Some providers do that, some don't like to do that. What's the value of the report, right? And then thinking about litigation, once facts are out there, they need to be consistent. So there's also, I think, a lot of things have to be done at the end of the investigation to coordinate potential notifications across the world in different jurisdictions, so that the facts are always the same, and if facts are disclosed about the data, then this is not inconsistent. So these are just a couple of examples from practical experience.
And that is completely indirectly connected with the need to have evidence of the breach, which is also linked to that forensics report. And Thomas, if you want to jump in and provide.
Yes, I'd like to add up to what has just been said by Lorenzo and Jörg, because the way to address, more usual compared to my usual practice, trade secret breach is really similar to what we heard in terms of reaction to cyber attacks. Of course, you need to immediately stop the breach, cancel right of access to the employee, for example, and then you need to gain evidence and collect that evidence and audit the extent of the breach. What information has been copied? You need to have that information. You usually need to engage forensic experts, IT experts, alongside with bailiff, depending on the countries and the legal practice there. But of course, gaining access to the computer, for example, employee's computer, see what information has been accessed, the references of the USB sticks or the external memory that might be used is, of course, relevant information. And all this needs to be arranged very quickly. So companies and of course their external attorneys need to be prepared and be experienced to do that. One tip I would add to what Lorenzo has said is, it's obvious, the earlier you detect, the better it is. And in addition to monitoring, I think companies should consider adding alerts. When data is accessed or data is copied, sometimes it's possible for the IT system to say, are you really willing to send an email containing that document outside of the company? Sometimes it's perfectly okay, but at least having those kind of alerts can prove to be very useful, and also it creates an atmosphere on the employee side, knowing that they are monitored and that kind of downloading information on a USB stick. Why not create an alert? Do you really want to do that? Those could be part of the reasonable measures to put in place.
Yeah, and let's get to finalize this this topic, the perspective from the business from Frederick at bioMérieux. What's your experience there, if you can share it with us?
Actually, what Lorenzo said and what Thomas said is put in place at bioMérieux. The incident response plan, all the tools for scanning, the server, the test stress, everything is put in place. But in addition, I would say we organize our data by specialties. We've identified owners that regulate their access. And if one wants to have access to a particular information, he must ask permission to its owner. We have also specific tools to share information with partners, which tools differ depending on the sensitivity of the data. And similarly, depending on the data sensitivity, we use different types of storage servers. We have also data cycle management. For example, once a project with a partner is done, confidential information is deleted from those tools and stored in specific servers. And also very important to minimize the risk is the awareness of the employees, once more. They are trained on that topic. For instance, any new employees coming at bioMérieux has to follow a specific training on cybersecurity and confidentiality. And it's not sufficient also to think at an individual level, as Lorenzo said. We put in place a network of business representatives that is trained to data breach and has several roles. Raise awareness in their department and escalate anytime they think there is a risk of data breach. So it's technical measure, individual measure, and group measures.
Sounds like a great plan. Let's move on to the next slide and the final block, which is obviously the enforcement and the remedies. What's being done before the European and national courts, and what are the remedies? And if you want to start, Thomas, by looking at the European courts practice.
With pleasure, Marta. I mentioned already that we see that the number of cases are increasing. We don't have clear statistics, but we see that clearly as a trend, and we see the US statistics, which are very impressive when you see the curve of the number of cases increasing. I would say that there are courts in most European countries which have now gained quite significant experience in handling trade secret litigation. The judges know very much what it is. They know how to manage those cases. And of course, the directive has helped a lot to increase also the judges' awareness and importance about protection of trade secret. There are some situations, however, where you need to end up before courts which have less experience. It happens in countries, and I'm speaking about France, where trade secret litigation is not handled by specialized courts, so you can end up in many different courts, sometimes with less experience. And that's why in those courts, it's even more important to be able to bring a clear case with clear evidence, and in particular, clear evidence of policies being put in place within the companies. One important aspect of trade secret litigation is the critical importance of evidence. I mean, that's true for any dispute, whatever the subject, but it's even more critical and more difficult with trade secret, because in order to prove a breach and a violation of trade secret, you need to prove first that there has been access to the data. So you need to prove that there has been copy, sometimes illegal copy. So the journals of access to information, any evidence I mentioned earlier that information could have been recorded on a given USB sticks or outside server, etc., is relevant. You also need to bring evidence that the accused product or service has been designed using the trade secret. And that's really different, for example, if you compare to traditional patent litigation, where you simply need to compare a product versus claims. There you need to understand and bring evidence as to how the product or the process was designed, and you need to show evidence that the trade secret has been used there. So you really need to have access to that. And to have that, I mean, there are tools which really depend and based on the rules of civil procedure in many countries, or also sometimes criminal procedure, because sometimes it's useful to use criminal courts in order to facilitate some means of gaining evidence. But in some countries like the UK, you would use disclosure. In other countries, you would rely more on search and seizure for evidence. So all that needs to be part of a global approach based a lot on forum shopping to be an experience court, to use the rules of civil procedure in some countries. So yes, that's how things are being used and those cases being trialed. And I would say I leave it to Rebecca maybe to supplement what I've just said and also to address the issues of the remedies.
Yeah, sure. I mean, I think, you know, you've touched on the fact, Thomas, that in I think in these trade secrets cases, more than perhaps any other, acting quickly and obtaining urgent relief is a priority for businesses, primarily to stem the flow of or the disclosure or misuse of the trade secrets. Not least to retain the quality of confidentiality of the trade secret in the first place. So there are fortunately a wide range of remedies available throughout the European courts, including a range of urgent injunctive remedies, such as the search and seizure orders that Thomas mentioned, where the wrongdoers could be required to deliver up any devices on which the claimant suspects their trade secrets are held, so laptops, mobile phones, USB sticks, etc. There are prohibitory injunctions available to try and prevent disclosure of trade secrets or misuse of trade secrets in the first place. So that's a preventative step. Obviously, the bar is very high for obtaining these types of remedies because they are so drastic in nature. So it becomes a bit of a chicken and egg situation to have the relevant evidence. This again is picking up on what Thomas has just said. You need the evidence in order to get the remedy. So it's also all the more important that you have the right policies and procedures in place so that you can show the court that your trade secrets are really trade secrets and that you've tracked the access and the disclosure, unauthorized disclosure of them. Just to wrap up, I guess, on remedies, obviously there are financial remedies available, the usual that you'd expect, damages to compensate the claimant from the loss to its business from the misuse of the trade secrets, or you can, certainly in the UK, you can opt for an account of the profits enjoyed by the defendants from their misuse of the trade secrets. And there's a whole range of financial remedies in between those two options. Often you see royalties being calculated by the courts to compensate or certainly provide some financial benefit to the claimant from further use of its trade secrets by the defendant and further by third parties. So yeah, a wide range of remedies, but not always easy to obtain.
Yeah, of course, no, easy by no means. And so finally, we go to enforcement, where Georg can potentially give us a few tips on the enforcement perspective.
Yeah, just quickly what we see. I mean,
Yeah.
the obvious is obviously two things here, right? When we look at that, we have law enforcement agencies, because we're talking criminal activity to a great extent, right? In most of the instances, especially external, but could also be internal activity, of course. And that's next to that, we see, of course, data protection authorities bringing enforcement, meaning fines, where the fines are imposed for not notifying incidents properly, not at all, or too late in terms of GDPR, 72 hours and so on. So we see fines here. At the same time, what's happening is that authorities also investigate more and more in context of an incident. What is the actual security controls that have been implemented by the organization? So we have seen companies getting a fine not only in terms of not notifying properly the authority or the individuals concerned, but also then receiving potentially a fine for not having appropriate security measures, right? So there's a trend that authorities understand the connection and then look into that in more detail. I think that's it, what I can share on that.
Very good, thank you. So we'll just end up with on the next slide with the top tips, and I would ask our experts Lorenzo and Frederica to share with us one top tip, each of them, on how to keep the source secret, how to protect trade secrets in the cyber world. Maybe start with Lorenzo.
Yes, for me, as I said before, the most important thing is approach cyber as a company problem, as a company issue, as a company responsibility. And so using a risk-based approach to invest the right money on the right critical assets. In this case, the critical trade secrets. So this is the most important tips for me.
Yeah, and I'm aligned with Lorenzo. Rely on your organization. Work closely with the IS in the privacy department. Give roles and responsibilities to your employee. And when you set up a trade secret process, do not forget your innovation needs that often require information flows at high pace. Be business oriented.
Mm-hmm. Very good. Anyone else wants to offer a tip? Georg, Rebecca, Thomas?
Yeah, sure. I would have only two. I mean, number one is develop a good incident response plan, right? We had addressed that several times during this conversation. That's really crucial. And that plan should not be drafted only by IT, only by legal, right? It needs to have input from many different people in the organization. And then also putting that plan into practice. So what we see is what we recommend is doing a tabletop exercise on a fictional breach, right? So it's so that the organization is prepared. So really go through it, go through the plan, apply it in practice in a fictional incident so that everybody understands what needs to be done in case of crisis. The best plan is nothing worth if it's not being trained on.
Right. Yeah.
I mean, I would add, I mean, prevention, not cure, is the key here, given that once a trade secret has been disclosed in an unauthorized way, it may lose its value and its status altogether. So it's all about preventative measures, and you're required now to do that under the directive as we've been exploring. So you won't get a case off the ground unless you can show that you've taken those steps. And I just echo what's been said before about you have to engage with the different parts of the business that are relevant here, which are many, HR, IT, commercial, IP, and sort of coordinate it all.
Good. And Thomas, do you have any tips?
I have many tips, but they're fully in line with what has just been said. I mean, time is of essence and anticipation is key. So definitely you need to have a trade secret policy drafted that you can take out of the drawer to show to the court. That really helps to have that handy. And yeah, try to detect breach as early as possible. And again, this requires and can be achieved only with the cooperation of everyone. So it includes HR, when they are departing employees, share information, try to understand whether those people have had access to confidential information or whether they've been working on hot topics, etc. So fully in line with what has been said to try and yeah, anticipate as much as possible.
Very good. So all these tips, we will be sending a list of these tips we've just discussed along with the PowerPoint presentation to the participants. And also we haven't had time to deal with questions, but any questions that any of the guests may have can be addressed. If you can go to next slide, Leah. To the final slide. Next slide. Yeah, any questions can be addressed to Leah, and we'll make sure and have the team address them to you. And that's all from us today. We thank you for the time and interest, and we hope to stay in touch.
All right, thank you very much.
Thank you very much.
Thank you.